Hello, I'm John Vanderloo, Editor of International Employment Lawyer, and thank you for joining today's webinar on responding to whistleblowing complaints around the globe. Whistleblowing has been on the rise since the start of the COVID-19 pandemic, and businesses are expected to face even more reports as workers begin to return to their workplaces. Today, we are joined by a panel of experts from Freshfields to discuss how employers should best respond to whistleblowing complaints and what trends to expect over the coming months. As always, before we get started, there are a few housekeeping points to cover. First, please use the online question tool to post any questions you might have for our panelists, and I will share these with the speakers during the Q&A session at the end of the presentation. Second, if you have any audio-visual problems during the presentation, please let us know by using the question tool, and a member of our team will be on hand to support you. And finally, just to note, today's session is being recorded, and we will share a copy of the recording via email and on IEL in the coming days. Now for the introductions. Holly Inslee is a partner in London. Next to a wide-ranging contentious practice, she regularly undertakes investigations into sensitive employment-related issues, as well as advising on the employment aspects of regulatory and competition-related investigations. Holly is particularly interested in the drivers of corporate culture and the impact of culture on employee conduct. Next, Stephanie Cho is counsel in Hong Kong. She has a broad range of expertise advising on employment, pensions, and benefits issues in an advisory, transactional, and contentious context. She regularly advises on Pan-Asia projects, including in relation to whistleblowing projects and investigations. And last but not least, we have Thomas Gwenetsky, is a counsel in Dusseldorf. He advises on various employment issues, including advising on sensitive compliance matters, whistleblowing structures, and international cross-border investigations. A particular focus of his is striking the right balance between compliance requirements, labour law, and data privacy restrictions. And in connection with his work in the US, Thomas regularly works with Freshfields' New York office. So, without further ado, I'll hand over to Holly to begin the presentation.
Thank you very much, John, and hopefully the slides will make their way back to the beginning. I think they've got a bit of a mind of their own at the moment, but while that happens, let me just start by setting out for you what we're hoping to cover today by way of an agenda, and hopefully it will appear in front of you shortly. What we plan to start with is our views on current and predicted whistleblowing trends. So just based on our experience of what we're seeing and what we've been seeing in particular over the last 18 months or so, because you almost can't have a conversation these days about whistleblowing trends without talking about the impact of COVID and the impact of the changed working environment. We'll talk about some upcoming legislative changes from around the globe, and you probably won't be surprised to hear that as part of that we'll touch on the new EU Whistleblowing Directive, which is one of the biggest of those changes. And we'll give our thoughts on establishing effective internal whistleblowing channels. We'll touch on the use of non-disclosure agreements, or perhaps more accurately, the lack of use of them, because I think it's fair to say that there are some issues with them and possibly some thoughts around the popularity of non-disclosure agreements. And we'll finish with some top tips in terms of avoiding litigation and reputational risk in the context of handling whistleblowing. So let me kick off first with our thoughts on current and predicted trends. And as I said, you almost can't have that conversation without mentioning COVID and the revised working environment, I'm afraid to say. There's a reference on the slide in front of you to a survey that Freshfields conducted last year, where we asked people across a range of jurisdictions for their views on whistleblowing. You're very welcome to access that, and I won't try to capture today all of the themes that came out of the survey, but I will mention a couple of them as we go through and where they're relevant to the points that we're making. The key headline, as you'll see on the slide, was that in contrast to our previous survey, which we carried out 3 years earlier, there was quite a negative response and an apparent decline in people's willingness to speak up and raise issues. And if there is a decline in confidence, I think the next obvious question is, well, why is that? And inevitably that answer will vary from company to company. But one point that we see being discussed time and again, and increasingly at the moment, is the impact of the pandemic, the impact of the altered working environment. And the question is that having an impact on either people's willingness to raise issues or the way that those issues are dealt with? And that's something that we'll come on to. Just anecdotally, we heard a lot of employers say to us that their experience was the number of whistleblowing reports they received, if you ignore kind of COVID, PPE related concerns, really dropped in the first few months of the pandemic last year, but did start to then recover again towards the later part of the year. I think the key message is that there is no substitute for knowing what your own data is showing and why. So were there particular spikes within teams or business areas? Were there unexpected dips in the number of concerns being raised relative to what you would usually see in a particular area? Or were there concerns being raised about different issues than the ones that you would typically expect to see? And that data can be really valuable in then informing things like, do I need to think again about my comms strategy around whistleblowing? Do I need to offer training in a particular area, in a particular type of conduct that seems to keep coming up and have concerns being raised about it? Does this suggest that there's perhaps a lack of engagement in a particular area of the business when it comes to whistleblowing, and I need to concentrate on that? So while there is no substitute, I think, for looking at your own data, I can share some points coming out of the survey that I think give you a bit of a flavour of what we found and the trends that we're seeing. First of all, there was a really interesting split based on age. So it seems that there is a greater willingness to speak up amongst the younger end of the workforce. There were significant jurisdictional differences, as we often see. So France and Germany in particular, people seem to be far less willing to raise concerns than they might have been in, say, the UK or the US by contrast. About a quarter of respondents, interestingly, thought that their employers' whistleblowing procedures needed to be revised because of the changes to the working environment that COVID had caused. And that takes us on to the next point and onto the next slide. And that point is around how might you need to alter your arrangements to adjust to the new working environment, whether that's a hybrid environment or a completely remote environment. And it falls really into two sections. So how do you ensure that you're encouraging reporting, and do you need to change what you're doing there? And how do you then deal with the issues that are raised through your whistleblowing arrangement? So if we can move on to the next slide, I'll talk about that. Thank you. If I pick up first on the point about encouraging reporting, I think in a way it takes you back to where I started, which is you need to understand your own data and you need to understand what's happening within your own organisation in terms of peaks or troughs and people raising issues. If any lower level of reporting is down to visibility of issues, so it's just harder to spot wrongdoing, for example, then that is a particular worry, and I think quite a difficult thing to tackle. It's certainly, I think, a worry for compliance and HR and legal teams across the globe who are trying to figure out, are my risk management processes fit for purpose in this new environment? But if any decline in the number of reports that you're receiving is more about engagement and about needing to encourage people to raise concerns, and that is arguably easier, I think, to tackle. So you should be asking yourself questions like, does our whistleblowing policy still suggest the right and most appropriate channels for our working environment? If there's a strong focus on, in the first instance, using an informal channel like a conversation with a manager, does that work as well in a hybrid or fully remote environment where you can't just knock on the door or put your head around somebody's door and have an informal chat? It might feel more difficult to do via video or on the phone. Even if it's not specifically COVID related, I think there is a question about whether it's just time for a refresh, if it's a while since anything was changed in terms of whistleblowing arrangements. And going back to the statistic I mentioned earlier, if the younger end of the workforce are more inclined to raise issues, are you engaging with them in the right way? So should you be using an app, for example, rather than having a traditional phone line for people to raise any concerns? And I think you also need to think quite critically about your whistleblowing policy. So has it kept up with the new working environment? If it gives examples of the type of behaviour you'd want people to call out, are those examples sort of fit for purpose in the new working environment? And I think harassment is quite an interesting example of that. So actually, does your policy acknowledge that if harassment is something that you would put through the whistleblowing route, that people can feel just as harassed by someone's conduct over video, for example, as they might do if they're physically present in the office? So there's definitely an exercise to do value, I think, in looking through a slightly different lens at your current arrangements and thinking, do these still work? So that's about making sure concerns are raised in the first place. There's then a sort of part two, which is if concerns are raised, you're likely to need to investigate them. And the way in which you do that might be different in a more remote environment. So Stephanie, I wondered if I could hand over to you to share your thoughts on that point.
Sure, thanks very much, Holly. I think that conducting an investigation when employees are working remotely, either fully or partly, poses a lot of different practical challenges, especially when it comes to collecting evidence. I think the best way to tackle this really is to have a game plan. So the questions to ask yourself are, what evidence do you need to collect? Where are these likely to be stored? Is it possible to have remote access to these information? And if so, what are the limitations and what do your policies allow you to do? Do they allow you to have remote access to them without consent of the employee? I think in the most serious cases, employers will often want to seize devices without advance warning in order to avoid deletion or destruction of relevant evidence. But that element of surprise is clearly much harder to achieve in circumstances where the employee is not physically present in the office. I think if the employer doesn't wish to implement some sort of dawn raid arrangement, then care needs to be taken, obviously, to ensure that the employee's rights are not breached. I think where so many countries remain in lockdown or are going back into lockdown, the logistics of collecting a device from an employee is also an issue, because who do you send to pick up the device, and do the rules on lockdown allow for that? I think because of these logistical challenges, it may be that the only materials that can be used are the ones that are held remotely. So data that has been stored on the cloud or on a server. And so it's important then to identify as soon as possible which materials will be required, and then to check with your IT team on how these materials can be accessed, and if it's possible to recover any additional data remotely from work devices. So if employees have work phones, if they use Teams chats on the work phones, can that data be retrieved? I think chances are there will be limitations as to how much you are able to collect. And I think the other question is, what happens if you need to collect hard copy documents? If hard copy documents are held at the homes of employees, for example, then you may need to think about document preservation notices if you're not able to collect these immediately. I think importantly, companies just need to have sufficient leverage in their policies to be able to get access to digital devices. So now might be a good time for companies to start reviewing and updating policies to make sure that they have the relevant powers to obtain data where employees are not physically in the office. For example, it might be beneficial to update device policies or IT policies to require cooperation of employees where needed and where a device cannot be remotely accessed.
Thanks, Stephanie. So we've talked a little bit about change in terms of trends that we're seeing, change driven by the working environment, but I said that we would move on to talk about legislative change. And one of the big changes, certainly if you're sitting anywhere in continental Europe, is the Whistleblowing Directive. So Thomas, let me hand over to you to talk about that.
Thanks, Holly. So you're absolutely right. I think one of the biggest global developments in terms of whistleblowing and legislative changes there is the upcoming implementation of the European Directive on the whistleblower protection. What you see here is essentially a map of where the implementation process stands in the various European countries at this point in time. We'll talk about that here in a second, but maybe just to give you this general overview that the most European countries are a little bit behind schedule on implementing whistleblower protection laws. As you can see here with the orange and the red countries, basically not having progressed very far with the implementation laws. But maybe if we go to the next slide, I would just give a brief introduction of the sort of the core terms, most relevant elements of the directive, just to highlight a few, just to set the scene of what the European landscape looks like and what it will look like most likely in the near future following those changes under the directive. So the European Directive on whistleblower protection is essentially a regulation that is intended to establish minimum standard for the protection of whistleblowers, in particular by introducing certain elements that are in some jurisdictions, some European jurisdictions relatively new, in some others they are more established, but it's really the aim of the directive, which is common for a European directive, is to establish a common minimum standard across all of Europe. So those elements in particular include protection of the whistleblower against any forms of retaliation, also to create a procedural advantage for whistleblowers by creating a reversal on the burden of proof in case of disadvantageous treatment of the respective individuals, protection against damage claims that whistleblowers may be exposed to, also making damage claims easier for whistleblowers on the other hand. So there are a number of elements that are introduced in the directive. However, they will not become directly, or the regulation, the directive is not directly applicable to the private citizens of private companies within the European Union in order to ensure that implementation laws need to be adopted by the various member states that will implement what is required under the directive, and the respective deadline is 17 December 2021. So it's about to expire here pretty soon, and given the COVID pandemic and all the things that were that needed to be dealt with, I think it's pretty understandable that a lot of the countries, as I just stated, are a little bit behind schedule. A few countries are on schedule though. For example, Sweden is to adopt its Whistleblowing Protection Act today, as a matter of fact, and Ireland and Czechoslovakia are other countries that are currently in the process of implementing that in time. Other jurisdictions like Germany, for example, had a draft law, but that process is now, due to the general election and the starting of the new parliamentary session cycle, is discontinued and will be reinitiated here fairly soon. So if we go to the next slide, who's covered under the directive? Essentially, a number of individuals can be protected as whistleblowers under the directive. Employees being on the core of that group, as employees are typically close to any forms of reportable misconduct or violations, as they are simply being in the companies, are therefore often able to spot the respective issues. So they are, of course, at the core. What the directive covers in terms of reportable offenses are essentially breaches of European Union law, which is due to the structure of the European Union, that the European Union cannot easily legislate anything that's just restricted to the national member states. What you do see, however, is that European member states are free to exceed that minimum standard. And for example, Sweden, but also the draft of Germany, provided that reportable offenses under the respective national implementation laws will not be restricted to European legislation, but will also go beyond that. Also, one argument for that being that it will be rather difficult for the whistleblower to judge whether that report that he or she has been filing is really based on a violation of European law or not. One other core element that's worth mentioning, which is now implemented under the directive, is the establishment of internal and external reporting channels for companies of a certain size, essentially starting with 50 employees or more. And we'll talk about, and Holly we'll talk about that here a bit more in a second. There will be an obligation to report or to establish internal reporting channels, but the employee is free to choose between internal and external reporting, so either within the company or to a designated authority to report certain forms of misconduct. If that is not successful, internal or external reporting, or it can be determined already at the beginning that such reporting will have detrimental effects to the whistleblower, there's also the possibility of a public disclosure in particular to the media, but that is a very restricted approach. This election right here between internal and external reporting is actually something that is somewhat contrary to what has been the trend in the courts across Europe, in particular the European Court of Justice, but also, for example, German courts, that essentially had the view that it is a duty of an employee to try to report internally first, but that is something that has not been adopted under the directive. So maybe we'll go to the next slide then. Yeah, I think the two elements mentioned here, the implementation of the directive across the member states, I already mentioned that point. We will see and expect to see more activity in that field towards the end of the year, as most countries are now entered into that legislative process. And what will be one major challenge for companies operating throughout Europe to deal and handle and essentially balance between the different implementation laws that we will see, because there will be deviations among the different member states on how to implement the directive.
And Thomas, just to pick up on that point, I mean, you talked about the fact that there is understandable delay in a lot of the member states. So what do you see employers actually doing practically? Are people still trying to get ready for the directive, or are they really in wait and see mode to actually see what comes in each member state in terms of implementing laws?
Well, I think there are different strategies, and it really depends on how far you have progressed on your trajectory on developing a good whistleblowing system. So there are certain things that are almost inevitably to come, irrespective of whether the implementation law is already there or not. So those elements that I've talked about here, in particular the internal reporting obligations, the structure to ensure confidentiality, things like that, they will definitely come, and we do see companies to a certain extent waiting for the implementation laws to come. But at this point in time, I think it is wise for companies to look at their whistleblowing structure already based on the directive and see, do we meet those core elements of the directive already, or do we have structural issues with that? So if, for example, internal reporting lines is something that will need to be established, and making sure that only a restricted number of people will have access to that information is not only a core requirement under the directive, it's also something that's required under GDPR. I think two other elements that will be important and can already be foreseen now is that companies do have a structure and mechanism in place to ensure that they will be able to address this burden of proof issue. That's the reversal on the burden of proof, which essentially states that whistleblowers that receive some form of negative statement or negative treatment could claim that the employer has the burden of proof that this was not related to any kind of reported misconduct. So companies should actively think about how to address that, for example, through better documentation of certain decisions being taken in order to address this issue.
Thanks, Thomas. And maybe if I just pick up on the final point that's on the slide there, because that's a topic that I've heard a lot of discussion around. This point is around the fact that the directive refers to legal entities, and the requirements it imposes are imposed on specific legal entities. That then begs the question, what happens if your current whistleblowing arrangements involve reliance upon some sort of centralized system? So perhaps a reporting hotline that's operated by the parent company within the group, reliance upon a central compliance function or some other investigating function to deal with issues that are raised. Can you continue with that? Or does each entity in the group or in each member state have to have its own arrangement? In summary, what the European Commission says is you can absolutely keep those centralized arrangements and encourage their use, but you do have to also make available a more local route so that a whistleblower has a clear choice to reject the centralized arrangement and to insist on their concern being addressed at an entity level. And that's something that has sparked quite a lot of debate and discussion within Europe. If you think about, and we'll come on to it a bit later again, the arrangements that a lot of big corporate groups operate, you know, a central system is a core part of that, and they see that actually as an advantage. So the idea that they might have to start to kind of fragment things a bit more and operate something on an entity specific basis, I think is causing some concern. I'm conscious we could spend the entire time on the directive, but we won't do that because we have promised a slightly broader session. So we can move on and just talk about the picture elsewhere and beyond Europe. And I can very briefly just touch on a couple of points for the UK. So first of all, we won't be implementing the Whistleblowing Directive because of Brexit, but there are still some consequences, I think, of the directive coming into force. And one of them is that, for example, there has been a proposal by one of the major whistleblowing charities to put in place some new whistleblowing legislation that does track several of the provisions of the directive. For example, the requirement to give feedback at various points during the whistleblowing process. There is also a proposed new whistleblowing bill, which, if it were introduced, would create 2 new criminal offences. So a criminal offence of failing to deal adequately with a whistleblowing report, and a criminal offence of subjecting somebody to a detriment for having blown the whistle. Now, we're a long way from that actually being passed into law, but it is still very interesting, I think, to see the sorts of proposals that are being made and the real strength of feeling behind this. And there is definitely, I think, momentum in the UK getting behind the idea of a change in the whistleblowing legislation, because it's been in place for some time, and I think quite a few people feel it's due a refresh. So Stephanie, let me hand over to you to talk about the picture elsewhere.
Thanks, Holly. I think the general consensus is that whistleblowing legislation is generally more light touch in this part of the world compared to the EU, the UK, and the US, and that developments are generally, few and far in between. That being said, we have seen some important legal developments in Singapore, Australia, and China more recently. In Singapore, the stock exchange made some important changes to the listing rules this year, which will take effect from 2022. So all public companies must now establish and maintain a whistleblowing policy, which needs to be disclosed in the annual report. The Singapore Code of Corporate Governance already includes certain best practices for whistleblowing, like requiring a listed company to have designated function to investigate whistleblowing reports, or taking steps to ensure that a whistleblower's identity is kept confidential, and generally ensuring protection for the whistleblower. Going forward, listed companies will now be required to explain in their annual reports how these practices have been implemented within the organization. And this is significant because it is the first time that there has been any sort of legal requirement for Singapore entities to have whistleblowing arrangements in place. There's also a new-ish act in Australia, which basically provides for a more rigorous set of protections for whistleblowers than was previously offered under the then existing laws. The key amendments took place in 2020 and effectively required different types of companies, and mostly public companies and large proprietary companies, to put in place a whistleblowing policy with certain mandated content. The Australian regime is probably the most comprehensive whistleblowing regime that we've seen in APEC so far, and is probably the closest to the European standard. In China, we've also seen some interesting developments, which will take effect in December this year. The State Administration for Market Regulation announced some new regulations in July this year, where whistleblowers who report material violations of law and food safety, drug and product quality may receive a financial incentive on successful prosecution. The maximum reward is about a million renminbi. It's not the first time we've seen financial incentives being used in China, but renminbi 1 million is certainly the highest amount we have seen so far. Next slide, please. And on that front about financial incentives for whistleblowing, I thought I would share an interesting update that caught our eyes in the US. So the US is well known for offering financial incentives for whistleblowers to report matters directly to the SEC. The SEC said earlier this month that the total amount of payouts that it has made to whistleblowers has topped $1 billion US, and that it has paid more than 2,007 whistleblowers since their program began. And I think what's really interesting here is the different approaches between the US, the EU, and Asia in terms of financial incentives. I think the use of financial incentives tends to be quite polarizing in this part of the world, and as I understand in Europe too, and in the UK. Our 2020 whistleblowing survey results showed that more than 40% of respondents in Hong Kong, for example, thought that financial incentives would encourage people to make false claims. I think with the exception in Asia, I think it's South Korea and China, which is now beginning to experiment with the concept of financial incentives. Very few jurisdictions in China use this as a way to encourage whistleblowers to come forward. I think what will be interesting is, whether or not the use of financial incentives will begin to pick up momentum in other parts of Asia, especially if China begins to have success with its program.
Thanks, Stephanie. And I think it's fair to say the position feels the same to me in the UK in terms of financial rewards for whistleblowing being quite polarizing. We'll move on now to talk about establishing effective internal whistleblowing channels. One of the pillars of the directive, for example, that we've heard about is the requirement to establish internal channels. Establishing those channels is one thing, making sure that they're effective is obviously another. And the effectiveness of your whistleblowing arrangements and people's engagement with them is really critical to ensuring that they're used, obviously. When thinking about the steps that companies can take to improve the level of engagement with their whistleblowing arrangements, one suggestion that I often make is to have some sort of demystification session. So people can be very uncertain, I think, about what will unfold if they raise a whistleblowing concern. Is there immediately going to be a very formal investigation? Am I going to be grilled by lawyers? Is somebody going to get into trouble? Am I going to get into trouble? And I think there can be huge value in explaining to them just mechanically how the process typically works. What happens when you raise a concern, and maybe with a case study or a real life example to hopefully reassure them this is what it will look like. It's not as bad as it might seem. And they may then feel more empowered and more willing to raise an issue in the future. So demystification, I think, is one thing that can really offer a benefit in terms of making your arrangements effective. Stephanie, in terms of internal versus external reporting, I think there's always a bit of a tension there. I wondered what your perspective is on the issue of internal versus external, which people tend to use, what the position is in Asia, for example.
Sure, thanks, Holly. I think my view is that in Asia, there is greater tendency for whistleblowers to go external. And part of that reason is because many organizations still don't have internal whistleblowing frameworks. And even where there is a mandatory legal requirement to do so, they're often targeted at listed companies or those in the financial industries or companies in other regulated industries. So smaller companies or companies outside of regulated industries can often slip through the cracks. And even where there is a whistleblowing framework internally, they're often not well publicized or understood. And in many cases, they don't allow for anonymous reporting or offer protection for whistleblowers. I think the fear of retaliation is really one of the biggest reasons why employees choose to report issues externally rather than internally. And there's a really interesting phenomenon that we're seeing in China. Employees are increasingly savvy when it comes to using social media. So if an employee reports an issue internally, but the employer doesn't give them a timely response or doesn't give them a response they're satisfied with, they will take it to social media. And a post on Weibo or WeChat, which are the kind of big social media platforms in China, can go viral in a matter of minutes. And whistleblowers know this, and they know they can leverage on this to pressure, their organization or the regulator to respond to an issue. So I think a lot of this really just comes down to an issue of trust that the employee has, that the employer will investigate a claim properly and fairly and to protect them from retaliation. I think the more trust an employee has within the internal system, the more likely he or she will opt to use this as a channel for reporting their concerns first. Thomas, do you have a view from a European perspective? What does the EU directive say about internal versus external reporting?
Yeah, so again, there was sort of a shift here with the directive. Previously, under many court cases, it was fairly well-established practice that internal reporting needs to be prioritized over external reporting, mainly to ensure that the employer has a chance to remedy, to cure the issue, and also to avoid any reputational damage to the employer. It has been part of the discussion when the directive was being developed, but it did not make it into the directive. So at this point, there is really this option right for the employee to go either internal or to go to an external authority to make the report. So it will be important for employers to really create an environment for employees where they feel comfortable reporting internally and making the respective system accessible to them, promoting the system internally as well. And the point that you just mentioned, Stephanie, that it's not well publicized, and Holly, what you just said, that people may fear what happens if I report internally. Those are important elements for continental Europe as well, because if external reporting occurs, there is always a substantial risk, either because for the company, either because an external regulator would become of an issue before the company does, but also for another pretty obvious reason, there is an obligation for authorities to respond to a whistleblower within a certain period. 6 months is the maximum period under the directive. And if for whatever reason that external authority doesn't do that, there is an argument for the whistleblower for a public disclosure. So the information could go out to the media. And again, the first time that a company would learn about that would be from the newspaper. So it would be very important to actively promote those internal reports, because there's really no legal obligation anymore for employees to proceed that route first.
And Thomas, what about the group versus local issue? I mean, I've obviously talked about it in the context of the directive and the fact that you may need to have both, but do you have a view on which you see more of? You know, is it more typical to have a group arrangement versus something at local level?
Yeah, I think from the traditional perspective at this point, it's group level is clearly preferred from a compliance perspective. One reason for that is compliance structures tend to take the opposite view from compared to a data protection perspective, where you essentially try to decentralize information and spread it out, so things cannot be, you know, put together. And in a compliance structure, you would want everything to be centralized in one system. Especially US regulations require that in order to ensure that there is no material weakness in your compliance system. So there are regulatory but also structural reasons for having a centralized group level system in place. But what the directive now does, it essentially throws a wrench in there. It's just changing that whole setup, and it creates that need for companies to establish a more decentralized system, especially if you follow the view of the European Commission, which essentially requires to have a system established, or at least run on an entity per entity basis. So what we continue to see more and more at this point is a rather dualistic approach, where companies are at least actively considering having a decentralized system and a centralized system, essentially running in parallel in order to meet regulatory requirements, for example, on both sides of the Atlantic.
And just picking up from there, and we've talked a bit about what we see organizations doing. I think my contribution on that point would be that I have seen real evidence over the last few years of global organizations trying to promote speak up culture, and that's both through their communication of their speak up arrangements, but also a real concentration on allaying any fears around retaliation that might be suffered as a result of blowing the whistle. But there is a really mixed approach, I think, driven by cultural differences, legal and regulatory differences. I mentioned that our whistleblowing survey showed there were huge differences in attitude between different jurisdictions, so it can be really challenging, I think, to apply any sort of globally consistent standards. But Stephanie, in terms of promotion of whistleblowing arrangements, what do you see companies doing? What's an example of best practice on that front?
Yeah, I think communication and training are really key to the promotion of a whistleblowing system. I think with the pandemic and all the issues that have come out of that, whistleblowing in many cases may have fallen wayside. So perhaps the best thing to do, or the first thing to do, maybe to put it back on people's agendas or radars. And part of that is just reminding individuals of the expectation that the organization has in terms of speaking up about issues in the workplace. Pulse surveys, I think, can also help an organization gauge how well employees understand whistleblowing framework internally. And from that, I think an organization can determine whether further training is necessary, and if so, whether there are target areas to focus on as part of that training. In Asia, one of the key issues I often see is actually localization, and this happens with large companies that have operations all over the world. I think that sometimes in an attempt to have a globally consistent approach to things, companies can forget that what works for one country may not necessarily work for another country. I remember there was a case I worked on a number of years ago where there was an Indonesian employee who had gone straight to a regulator to report certain issues. And the company, which then subsequently spoke to the employee about this, the employee said he didn't report the issue internally because he wasn't sure what to do. The company then dug out a bunch of records which said that he had attended several different trainings on the whistleblowing framework, and they said, well, you clearly knew what to do. Why haven't you come to us? And it turns out that the gap was in his understanding. The training had all been conducted in English, and the employee had barely understood any of it. So I think the lesson there is really to make sure not to treat training as a box-ticking exercise, and to make sure that materials that you have are considered from a local perspective, whether it's the FAQs to a whistleblowing policy, or if it's the training materials, or even the posters around the office. I think there's just no point to any of this if it's not understood locally by the employees.
And it sounds like a really fundamental point, but I think a worthwhile reminder, especially if your materials are created at a sort of centralized level, making sure that they are then sufficiently localized that they will land in the right way. I think we might move on to the next section, which is a brief one, but a point we thought was worth raising, and that is around the use of NDAs. I think you'll probably hear a relatively consistent message from all of us in terms of our thoughts on NDAs and their use at the moment. Just to add my perspective from the UK angle, there has been a lot of focus on NDAs in recent years, arising largely, I think, from the Me Too movement, the perceived misuse of NDAs in a sort of Me Too context. And that has led to a few things. There's been a real focus on the fact that we do already have some regulatory and legislative provisions that prevent you from effectively gagging whistleblowers. You shouldn't be doing anything to stop somebody from blowing the whistle, but there was a perception that some confidentiality obligations had strayed too far in that direction. And one of the consequences of that focus was that the Solicitors Regulation Authority, for example, which is the organisation that regulates lawyers in the UK, issued a warning notice to all of its members about the use of NDAs. And that's really put it front and centre as an issue. People are quite wary, I think, of being seen to do anything that looks like gagging. And I'd say I see confidentiality provisions used less and less in this context. Stephanie, I don't know if that's a sort of similar position in Asia.
Yes, absolutely, Holly. I think in Asia, standalone NDAs in relation to whistleblowing are very rarely used. Typically, we will see confidentiality clauses included in settlement agreements and perhaps employment contracts, but even then, whistleblowing is often expressly carved out. I absolutely agree with your point that you made, which is that employers are increasingly concerned about the risk of being seen to gag somebody, and that's putting employers off from using confidentiality provisions in this context.
And Thomas, would it be the same in Germany, or to the extent you can comment, continental Europe more widely?
Yeah, I think it is. I think it's pretty consistent with what you two both said. So anything that looks like you're trying to silence a whistleblower is clearly avoided, and that goes even to things like when you're talking about settlement agreements, termination agreements, that no severance is paid, or that you should be careful at least with paying severance that is off market, that could be perceived as an additional premium for people staying silent on a certain issue. From a regulatory perspective, that is also important, because an employer must not put anything or must not establish any kind of obstacles that would actively prevent an employee to report externally. But it could also be an issue from other regulatory aspects like antitrust regulations, where an employer could be held liable or exposed to risk if anything is done that would even just look like you're trying to pay hush money to an employee on certain issues.
So I think the overwhelming message is proceed with caution if you're in the territory of thinking you want to put in place an NDA or even a confidentiality provision within another agreement. If we move on to the final point we wanted to cover today, and we are then very happy to take any questions if anyone has them. We thought it would be worth leaving you with each of our sort of top tips in terms of managing risk. And the consequences of mishandling whistleblowing can be far greater than one piece of litigation. There could, depending on the sector you're in, be regulatory enforcement risk. There could be financial and reputational consequences. And fundamentally, there could be a really damaging impact on your speak up culture as an organization if you're perceived to have handled something badly. And in turn, that can have an impact on your risk management efforts, which whistleblowing forms a core part of. So in terms of top tips for managing risk, if I kick off, I think I would put feedback very, very high on the list. And it's interesting because it's one of the sort of core requirements that's going to be introduced under the Whistleblowing Directive. But I think there's a real need to ensure that whistleblowers don't feel like their concern has gone into a black hole, and that they then need to take further steps to escalate the issue to make sure it's sufficiently addressed. It goes back in a way, I think, to the internal versus external reporting point that we mentioned earlier. If somebody raises something and their perception, rightly or wrongly, is nothing's been done about this, then I think there is a real risk that they will decide to take further steps. And even if you are working really hard behind the scenes to investigate and to deal with the issue, the whistleblower might not know that, and you might very quickly lose control of the process because they have taken matters into their own hands and gone elsewhere. So I would put feedback very high on the list of things to think about in terms of managing whistleblowing well. Stephanie, what's your top tip?
Thanks, Holly. I think my top tip is to consider what protections you have in place for whistleblowers and whether they're fit for purpose. As I said earlier, I think one of the biggest reasons why whistleblowers feel like they need to report externally, assuming there are internal procedures, is because they're concerned about retaliation. The Hong Kong Monetary Authority actually did an exercise last year, which was to ask a number of banks to conduct self-assessments of their internal culture. And one of the biggest findings that the banks had was that they needed to work on promoting an environment which provides psychological safety. And that is key to encouraging employees to speak out without fear of adverse consequences. So I think it's important for organizations to think about the protections they have in place for whistleblowers, whether it's measures to preserve their confidentiality, whether it's allowing for anonymous reporting, which I know can be an issue in some countries, or even changing working arrangements to put some distance between a whistleblower and the person they have made a complaint against, depending on the situation. I've said this before, I think it really comes down to how much trust an employee has in the employer and in the system, which will, determine whether or not they will approach the employer first if they detect an issue.
I think that
What about you, Thomas?
That point around psychological safety, we hear quite a lot these days, and it's interesting that the HKMA have talked about it, because the FCA in the UK has done exactly the same thing. Psychological safety is very high on the list. Sorry, Thomas, I interrupted you with your top tip. So what's yours?
So I think from my perspective, it ties in what Stephanie just said. I think especially if you're in a jurisdiction or responsible for a jurisdiction where traditionally there is a reluctance to report, I think it's important within your organization to create a culture shift where whistleblowing is not considered to be some kind of disrespectable behavior, but it's really a potential for companies and employees to create a better working environment and better operation. I think that's a pretty important part, because you do sometimes have the chance to analyze that, especially in international organizations. I had a client that has had operations in both North America and Europe, essentially the same size, and they had virtually hundreds of complaints in the North American organization and 4 in all of Europe for an entire year. So either there must be something totally wrong in the North American business, or this was clearly a cultural point. And I think making sure that this is understood is a big hurdle for companies, but it's something that really should be overcome, especially in light of this aforementioned situation where employees are free to report internally or externally, because whenever we speak to people, if people feel safe about the reporting, internal reporting tends to be preferred if they know where to go, because it's just the entry level is just easier if it's accessible, because employees may find it harder to go to any external authority. So making the entry level really as low as possible is key, I think, to kick off the process properly.
Thanks, Thomas. So we have left a few minutes in case anybody wants to raise some questions. I think some have been asked already. So John, I think I will hand back to you to be the question master.
Many thanks, Stephanie, Thomas and Holly, for sharing your insight on this topic. It's been really interesting. Yes, turning to the Q&A portion of the session. For those of you who have asked about receiving a copy of the slides and the report mentioned in the presentation, please don't worry, these will be sent to all of you along with the recording of the presentation later this week. In terms of the questions themselves, Holly, I think the first one is for you. One of our attendees says that in their organisation, a huge percentage of complaints in the UK come through as identity withheld. How can an organisation improve that stat as they cannot protect who they cannot identify?
It's funny, isn't it? Because in a way, as an employment lawyer, I always think, well, you're a bit better off if you don't know who someone is, because how could they turn around and accuse you of retaliating against them if you didn't know who they were in the first place? But that is far too simplistic. And increasingly, I've heard a lot of concern expressed that if you do have huge numbers of anonymous complaints, maybe that does say that there is some cultural issue around speaking up and people not feeling sufficiently sort of confident to do so. I'm completely stealing this from someone else now, but the Banking Standards Board in the UK identifies 3 things that it thinks can help you to encourage people to speak up, and I think in this case speak up and identify themselves. So you need to overcome the fear factor. So that's I think explaining to people your policy against retaliation related to whistleblowing, making sure that if there are any incidents of retaliation, you're absolutely cracking down on them and can be seen to be cracking down on them, so that that fear factor is hopefully reduced. They talk about futility, and that goes back to the feedback point I mentioned earlier. If people think there is no point raising a concern because it goes into a black hole and no one cares, chances are they might not raise it again. And that might also go, I think, to whether they're prepared to identify themselves. themselves? Do they think whistleblowing is valued in the organization? And then there's a sort of navigation point, and that goes to, I think, the demystification I talked about. Do people understand what they're getting into when they raise a concern? Are they worried about what it might entail? And the more you can do to reassure them on that front and explain to them, this is what it looks like. It's not a terribly scary process. You know, it's all relatively straightforward. I think you might encourage them to actually participate more fully in it and be prepared to identify themselves. But it's a really difficult perception to shift if you're in the territory where people aren't prepared to identify themselves because they think there is some issue. I'd say one of the most important things is probably trying to get to the bottom of why that might be through, for example, engagement surveys, pulse surveys, asking questions, doing focus groups. What is it that might hold you back from identifying yourself, so you can make sure you're tackling the right causes?
Right. Next question for Thomas. To what extent do organizations need to advertise external reporting?
Yeah, I think it's I think there is no very hard standard established in the directive for European, at least for the European sector. Again, there is a clear advantage for companies to do that in order to level the playing field with respect to external reporting, and in order to ensure that you keep control over your possibility to remedy certain issues. I think when it comes to your question, how much do I have to push this? I think it does help to actively also include employee representatives to the extent that you have them, because it creates an additional layer of trust for employees if it's supported by employee representatives, for example, like works councils and similar bodies of employee representation to address the issue.
And does the local reporting channel have to be an electronic one, or could an employer tell employees to report to their local legal compliance teams?
Yeah, so again, the directive is fairly flexible on that point with respect to Europe. So it is not entirely, it's not prescribed that a certain channel is mandatory, so that there's some flexibility to that. We'll need to see what the implementation laws say on the or whether there are any additional requirements on that. But at this point, there's a substantial amount of flexibility on that. When you do designate certain inroad, though, you have to ensure that the respective feedback requirements, coming back within 7 days to the employee to acknowledge that the report has been received, giving feedback within the first 3 months, that those requirements are complied with.
And Stephanie, would you generally agree that low or no reports from a certain jurisdiction have more to do with cultural hesitancy to report issues rather than a lack of issues?
Sorry, I missed the last part of that question. Can you repeat that?
I'll say again. So would you generally agree that low or no reports from a certain jurisdiction have more to do with cultural hesitancy to report issues rather than there being a lack of issues at all?
Yeah, I completely agree with that. There are lots of countries where I think, culturally speaking, employees just hesitate to speak up, either because of strong personalities within the business, or because of the stigma of being seen to report on issues in the workplace, and not to be seen as a team player if that was the case. So I do think that where we're looking at certain countries where the number of reports are low or none, that the company needs to have a closer look at the numbers to determine why that is, and to look at whether that fluctuates from year to year, or whether there's been a downward pattern in terms of number of reports received each year, and what the root cause of that might be.
Unfortunately, that's probably all we have time for today, but the panelists will follow up with those of you who have asked questions that we haven't had time to get to, so you will get answers to what you put forward. My thanks to Stephanie, Thomas and Holly for taking the time to be with us today, and to all of you who watched this session live. Just a reminder, the webinar will be recorded, and we'll be sharing a recording online in the coming days. Thanks for joining us, and we hope to see you at another IEL webinar soon. Take care and goodbye.